Now we have Glen Lucas.
All right. I'm going to give you some practical advice on how to deal with your assessment and your assessment appeals. Are there any lawyers in this group? Okay, because if there were, I was going to apologize to them right now. I'm a member of the Law Society. I'm a paralegal registered with the Law Society, and as I go through my explanation, you'll see why. It wasn't willingly. It wasn't something that I decided one day to stupidly do. Prior to 1998, you could go to the Assessment Review Board and you could stand up at the Assessment Review Board. You can explain your case with a single piece of paper or no piece of paper, and you could make some convincing reasons why your assessment was too high. Didn't matter if there were legitimate reasons. The board member would review that information. He would listen to what the assessment department had to say, or the assessor had to say at that time, and make a decision. Quite often that decision went in the homeowner's favor because the homeowner went there for a reason. 1998, the new Act came into effect, and the new Act said, okay guys, we're completely changing the system. We're coming to this ugly system we have now, fair market value. Between 1998 and 2004, there were 11 pieces of legislation that amended that original piece of legislation to turn it into an absolute nightmare. And some of those nightmares included issues where I go to the Assessment Review Board, I get this wonderful reduction, I get my tax bill, and all of a sudden my tax bill says, yeah, this is the reduction you got, but because of the legislation we're taking it back, and by the way, you're still paying the same amount of taxes as you were before. So I don't know if anybody here ever got caught in that, but it happened a lot, and it is still going on, and if you live in Toronto, it's still going on. And by the way, most of this legislation was brought into place because of Toronto. So it wasn't because of anywhere else in the province of Ontario. In 2008, and 2 years prior to 2008, lawyers got together and said, you know what, this assessment appeal business is a pretty lucrative business and anybody can do it. So Mr. Law Society, or LSUC as we like to call it, we need you to pass some regulations to curtail these guys from going out on their own and doing it, or having agents like this Mr. Lucas doing it for them and everybody else, because it was a big business. So they did. In 2008, May 2008, the Law Society says tomorrow morning nobody can practice except a lawyer unless you're a member of the Law Society. And then they came up with this wonderful test that guys like me would have to take, and to see if you would pass. So you had a whole bunch of these rednecks trying to take this course with the Law Society who were very prim and proper, and the two didn't mix very well. There were a lot of failures. Anyway, I got through somehow, but so here I am. So what happened is a lot of the tax agents that individuals would rely on, who in their past life were assessors that had retired, and these people could go and get information for them, were all of a sudden gone because they didn't want to do this. These guys had already gone through one retirement. They weren't going to go through this torture to work all over again. So over the course of between 2008 and 2010, we bought about 10 of these companies out and merged them with us. So we have a lot of people that have very good knowledge, ex-assessors, but can't go to court and stand up for people. As this process was going through in 2008, the Assessment Review Board had chairmen there that were more or less political appointees. They may or not known anything about real estate or land values. But the one thing is they had some common sense to them, and they would listen, and they would make decisions based on that information that they heard. The Assessment Review Board, the body that hears these cases when you can't make a deal with MPAC and you've got to go to the board, they said, you know what, our key people are lawyers, and we'd really like to have more lawyers sit on the board than anybody else. So today what you've got is you've got probably, I'm going to guess, 75 to 85% of the members that sit on the Assessment Review Board who are lawyers, and everybody who's been appointed in the last 3 years are lawyers, versus 10, 15 years ago where 1% were lawyers. So these lawyers think like lawyers, and I don't know about everybody else, but I find that lawyers just don't think like everybody else does. So it made the system complicated. The lawyers at the Assessment Review Board wanted to see the same process come in front of them as they would do if they were going to a divisional court to hear a case of a criminal case or any other civil case. So it meant that the first few people that went into hearings on their own got real surprises, including ourselves, because we were stepping through a different door. It was a different world when these guys started to take over. And we made lots of representations that this is wrong. You know, you can't conduct yourselves this way. And what happened was the board then started to come out with rules and regulations. And what they did was, after much lobbying on groups like myself and some other much larger groups, came out with regulations that said, okay, for the I'm not going to use this, I don't mean this in a negative way, but for the little guy, we're going to have this set of rules, and for the big guy, for the Ford Motor Companies of the world, we're going to have this set of rules. So you guys, you got big issues, you're going to have big expenses, you're going to have big problems. You guys can come in and do whatever you want to do. Well, that worked well, except you could see the trend. As more lawyers got appointed as chairman to the Assessment Review Board, all of a sudden this level started to move up to this level. And a practical example of this is, and I was amazed at this, last week we were in a hearing on a residential property. It was a fairly big property. It was a 6-unit apartment building. It was valued at $1.5 million. And I had brought in one of the assessors that we have hired to represent the value. So I had what the board would recognize as a witness, and I was going to be the advocate. I was going to be the guy that asked the witness questions. MPAC had the assessor, his notes, and all of the information. Now, the only reason that I had my other guy there was just pure luck, that I was too lazy to do the work that he had to do, so I shoved it off on him. So I had to bring him because I didn't know what the hell he was going to say. So we got to the hearing, and the chairman says, I'm going to cancel this hearing because MPAC don't have a witness. And in the legal world, it is the curse of the devil befalls you if you ever act as an advocate and a witness. So you can go into court and you can present the case, but you can't give any evidence as to why that case is what it is. Tax agents like myself have usually come from a background of valuation and then gone into the world of taxes. And so we know valuation first, and we know the law second. So we were a pretty good fit between the lawyer and the individual who did want to do the work on their own. Well, what this chairman was saying is that's gone. You can't do that. You got here. He's saying, Mr. Lucas, you have your witness here. Again, he didn't know I had been too lazy. You've got your witness here, so you've done everything right, but MPAC hasn't, so they've got to go away. Well, that day cost that client about another $500 because we were there. We were all prepared. We were there for 2.5 hours. We had 3 people there, and we had to go home. We've subsequently written to the board to say to the board, listen, you know, we have to have a meeting with you because you can't do this. You've got to stop this process. And the chairman that made that decision, by the way, was a lawyer. The Assessment Review Board have their own set of problems, and their problems is backlog and the chairman from hell. She has taken the position at the ARB. So if you want to know where the devil is at the ARB. And what she will listen to nothing, and she will listen to nobody, and her job is to stop as many appeals as she possibly can. And one of the tactics of doing that, for any of you that are going to hearings, is she will schedule 9 hearings on the same day with the same chairman. It's impossible to hear 9 hearings on the same day. So what she's trying to do is she's trying to force either deals to be made or people to go away. And I think there's an equal number of deals that are made and people that go away. Now, the good news is that MPAC are saddled with the same volume of work, so they want to make deals to make them go away as well. So there are benefits to that, but there's also a lot of problems with it. In our case, they've scheduled me for 112 full hearings over the next 6 weeks, which can't be done. We wrote to the board and said, listen, this is crazy. We've got to meet. We've got to talk about it. And I don't know whether this was a consequence of my letter or just happened to be that way, but I got 2 more notices of hearings in different courts in different cities for the same day. So now I have 116, but not all in the same place. Let's say you've got your information, you filed your request for reconsideration with MPAC. Don't wait for them to respond to you. Call and insist on talking or meeting with the assessor. Why? Because that screws them right up. They're not prepared for that. They're only prepared to deal with stuff they get in writing. So, and I've heard stories of assessors telling me, yeah, we're running a contest at the office. We're going to get $100 for the person that gets the most requests for reconsiderations dealt with in that week. Well, how do you make sure you win? You turn them all down. How long does that take? I could do 1,000 in a week, as opposed to doing 2 or 3 if they were doing them properly in a week. So that's a real story. So you don't know what's going on in the background. Also, if you're getting letters that are denying your request in August or September, the reason you're getting it is because the law requires MPAC to respond to those by September. So the closer you get to September, the more denials you're going to get. And we can almost be guaranteed that if we file requests for reconsiderations and we see that envelope come in August, it's a denial. Because they're just trying to get rid of them. They're just trying to meet the legislation and deny them. They may not even have looked at your property. In fact, I would say in all cases, the request for reconsiderations that we file, in many cases, ask for an inspection of the property, and they never contact us to do it. But if you contact the assessment department and you say, hey, I want to meet with you about this assessment, they have to meet with you, and all of a sudden you get pushed to the top of the list. So A, you're getting the information, and B, you're getting some real consideration. There's lots of good assessors out there. Most of the assessors are good. The managers are reasonably good. The problem is that the guys that make the decision and push their buttons are in their head office in Pickering, and I mean, they're just populated with idiots. So, I mean, one of the chairmen of the Assessment Review Board said to me one day, he says, Mr. Lucas, he says, the nice thing I like about you is I never leave here saying, I wonder what he was really thinking. Anyway, don't rely on the MPAC system that they tout on their website. You go to the website, we'll give you all this information, because what you don't know is that when you go onto the website and you put in your property code and your information, their system then immediately looks at what your assessment is, looks at the neighbor, and suppresses the information that would support a reduction, and will bring to the forward all of the information that doesn't support a reduction. And in the comments from one assessor, that doesn't seem right to me. We really should do something about that. So they haven't done anything about it yet. Their $200 million computer system. Because MPAC don't want to give anybody information, they don't want to buy a system that is off the shelf, and there's lots of them that are off the shelf. So what they do is they buy a system that is off the shelf, and then they spend a lot of money reinventing that system so that nobody else can use it except them. In this case, for the returns that we had in 2012, they had a bit of an issue. The company went bankrupt 90 days before the return of the roll. So all of a sudden, there's huge issues with the returns of the roll, and they can't correct them, and they still couldn't correct them. And that's why, if you're not getting any response from MPAC, it's probably because yours is one of those properties that have just gone into cyberspace and they can't deal with. We've seen parts of Ottawa. This is a good example where we've seen values of real estate from 2008 to 2012 decrease 60%. And my clients have been saying, oh, you've done a hell of a job. Yeah, thanks. But it's their system. Their system is just wrong. So in some areas, it's wrong on the low side. If you're on the low side, unless you like going home and whipping yourself with wet branches, be quiet. Okay? But they make a lot of mistakes. We see a lot of mistakes. I would say that of 50% of the people that come to us, there's mistakes in their favor in the assessments. So, I mean, they don't always make mistakes against you. They make a lot of mistakes, in your favor as well. They can correct those errors upon appeal. If you appeal it, they can go back and they can say, well, yeah, this is right. It should be higher. The other thing you're going to be faced with is you're going to get a package when you file an appeal and you go to the board. And MPAC, they tried this 2 years ago, and we fought with their lawyers over it, and it disappeared. And now they're back again with it. They come out with this huge package that they give you about why the assessment is correct. And 90% of that package contains a list of properties that have sold in your neighborhood to show what the average increase is. You can file that away because it means absolutely nothing. And we're hoping that the Assessment Review Board is going to quickly realize this. And after our case that we have with them next week, I think they should realize this, because it is absolutely lunacy, the form that they're using. All they've done is they've taken every property in a neighborhood of within 2 or 3 kilometers of your house. They've looked at all of those sales, they put those sales all together, they've averaged them, and they've come out with a number. And that number may or may not have any relationship to your house. So if you've got a 1 or 2 bedroom or 3 bedroom bungalow over here, they may have used a 6-story apartment building over here to do the valuation. So the only benefit to that form is, but it takes a huge number of hours to do, is pick out all of the inconsistencies in that form, point it out to the board so that MPAC can't use that form any longer. Now, mind you, in some cases that form may be good, because the City of Ottawa, if you're in the City of Ottawa, the City of Ottawa produces a map that shows how much your assessment has gone up by various regions from one assessment cycle to the other. So if in one appeal that we're going to be doing in the next couple of weeks, the City of Ottawa says the assessment went up 30%. The assessor's information, this whole package that he gave us, which is lunacy, we say, we're going to use it because his says it went up 13%. He doesn't know the city produced a document that said 30%. He should know, but he doesn't know. So we're going to go in and ask for the 13% instead of the 30%. So it's meeting with the assessor is very important. Having documentation with you when you meet the assessor is very important, although you can have discussions with the assessor and then follow up with documentation later, because you may not know what documentation to bring with you. If you wait until you get to the hearing, that's the wrong time to find out that you should have had documentation that you didn't have before. Because you can say my street doesn't have street lighting and therefore I should have a lower value. You won't, but I'm using that as an example. You better have some documents or pictures that show that you have no street lighting. So everything is evidence-based now. It's not just getting up like it was pre-1998 and telling your story. It is producing documents, producing evidence, and sometimes the stuff that you have to produce is absolutely, you think it's absolutely crazy that it's so, I don't know what the word is, it's so in your face that you should know it anyway. But you got to realize that when you get to the board, you're dealing with lawyers, and everything is not in their face. So you've got to prove stuff that is normally would make common sense. There's no common sense when you get to the board. If somebody thinks it's fair and you're going to face common sense, you will not. We've lost a couple of cases that I still shake my head over and wonder what the hell happened there. But anyway, I'm getting pretty close to, I'm over my time. Anybody got any questions?
Actually, I'm going to let you know the clicking you're hearing next door is we're half an hour into lunch.